as regards the court expressing it, conclusively determines the rights of the parties with regard to all the parties, all the matters, or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of a plaint and the determination of any question within section 144, but shall not include number A any adjudication for which an appeal lies as an appeal from an order, or number B any order of dismissal for default. Explanation: a decree is preliminary when further proceeding have to be taken before the suit can be completely disposed of. It is final when such adjudication completely disposes of the suit. It may be partly preliminary and partly final. The order rejecting the plaint under Order 7 Rule 11 CPC amounts to a decree under Section 2 Clause 2, and there is a right of appeal open to the plaintiff. Samsher Singh versus Rajendra Prasad AIR 1973 SC 2384. Essential elements of a decree. The essential elements: there must be an adjudication. In case of Deepchand versus Land Acquisition Officer 1994 SC 1901, the essential requirements of a decree were dealt in detail. The Apex Court opined that to constitute a decision of a court to be a decree, it must contain either of the following characteristics. Number A, there must be an adjudication, meaning thereby a judicial determination of the matter in dispute. Number B, a decision on the matter of administrative nature is not a decree. Number C, an order dismissing a suit for default of appearance of parties is not a decree. Number D, dismissal of an appeal of a want of prosecution is not a decree. Number E, any judicial determination can only be called a decree when it is passed by a court. Any order passed by an officer below the rank of a court is not a decree. The adjudication must be given in a suit. In Diwan Bros vs Central Bank of India AIR 1976 SC 1503, their lordship relied on the principle as observed in Hansraj vs Dehradun Masuri Electric Company AIR 1993 PC 6364. It has been held that the word suit ordinarily means it must have determined the rights of the parties with regard to all the matters or any of the matters in controversy in the suit. Such determination must be conclusive determination. There must be a formal expression of the adjudication, but every finding will not amount to a decree, even though it may conclusively determine the rights of the party with regard to some of the matters in controversy in the suit. A decision on a preliminary issue that the suit within limitation is mere finding on a preliminary point determining only the plaintiff's right to sue, and is accordingly not appealable and cannot be termed as a decree. A decree on a preliminary issue that the suit within limitation is mere finding on a preliminary point determining only the plaintiff's right to sue, and is accordingly not appealable and cannot be termed a decree. No, it determines only the right of the plaintiff to be adjudged as an indigent and does not determine the rights of parties conclusively, and the application becomes a suit after the leave is granted. The matter can be considered from another aspect as well. An order rejecting an application to sue as an indigent person for non-payment of court fee is a decree. A matter can be considered from another aspect as well. An order rejecting an application to sue as an indigent person for non-payment of court fee is a decree. A matter can be considered from another aspect as well. An order rejecting an application to sue as an indigent person for non-payment of a court fee is a decree. An execution proceeding, though a proceeding in a suit, is not a suit by the effect of Section 2 Clause 2 is a decree if so far as regards the court making it conclusively determines the rights of the parties on a question arising between the parties to the suit or their representation and relating to the execution, discharge or satisfaction of the decree. If the adjudication decides a question relating to rights and liabilities of the parties with reference to the relief granted by the decree, it is a decree unless it is merely incidental and refers to the conduct of proceedings. No, it falls short of the requirements of a decree and is merely an order which does not determine conclusive rights of the parties. It is only a proceeding which does not commence with a plaint. And the second essential element of a decree that the decision must have been granted in a suit is not fulfilled. A suit means any proceeding under the code which is instituted by the presentation of a plaint. Any proceeding under other acts which, according to a specific provision therein, should be regarded as a suit under the code. It is true that the purpose of the Amendment Act 1976 of Section 2, Clause 2 was to eliminate unnecessary appeals, and a number of orders passed under Section 47 CPC would be non-appealable. Nevertheless, there may be certain orders which may be appealable, which in turn would depend on whether such orders come within the definition of decree. Parsara Properties Limited versus AK Bose AIR 1979 Part 308. Yes, in this question arose before the Kerala High Court in Padinhor versus K. Bhaskaran, AIR 2002 NOC 248 Kerala. It was clearly held that the rejection of an appeal for non-payment of balance of court fees cannot be considered to be an order dismissing the appeal for default. It can be considered to be a rejection of the appeal, and therefore it is a decree in terms of the CPC. It is a decree in terms of the CPC in view of Order 7, Rule 11 and 12 read with 107 of this Section 107 of the Code. Distinction between decree and an order. So what are distinctions, please?